appeal in the matter of AM Belarus and the Secretary of State, Department. My lords, my lady, good morning. I have good news and bad news.
Oh dear. Are you giving us a choice of which we'll hear first?
Well, the good news, so far as the timings are concerned, is that I have instructions to withdraw reliance on the 2 points made in the respondent's notice, so I will not be pursuing that today.
Okay.
The bad news is that, pursuant to some points of clarification and some cases and other materials I referred to yesterday, I do have things to hand up this morning.
Have you got a little bundle between you? Because from the email from Mr. Dunlop, he's, I think, providing hard copies of something as well. Is that right?
That's right. I had two authorities which I've tabbed so they can go in the back of the supplementary bundle.
Right.
Oh, right.
Is it that one?
Oh, that's a supplementary bundle.
Yeah.
Thank you. Have you got 8 and 9 for that?
And Miss Weston, yours are?
Mine, I'm afraid, are in individual sort of sets of 5 documents. I think.
Fine. Do you want to hand them up?
Oh, I might have given you 5.
They're not what?
They're not tabbed.
No,
Don't worry.
Don't worry. 5 copies.
Thank you.
So I'd like to hand up 3 sets, if I may.
Yes, please.
One document I may not need to hand up. The court will recall that there was a hanging whether in paragraph, I think it was 139 of the Upper Tribunal's judgment. 142.
Sorry, 142 of the Upper Tribunal's judgment.
Yes.
And you suggest it is engaged.
Yes, but we don't need to speculate.
We don't?
Because, no, because Bailey must have gone back to the judge to clarify that, and the version on Bailey, which I printed off, removes the whether and puts a full stop at the end of the sentence.
Ah.
So we've made copies of that, which I can hand up.
Mm. Does that help?
Well, just so I'll read out the version in the Bailey. It may be that my lords, my lady can just amend the version that they have, rather than accept yet another document from me. That sentence now reads in the authorised version of Bailey. In approving the rules, Parliament has acknowledged that a period of 20 years spent in the United Kingdom is an important yardstick in determining the right to respect for a person's private life.
Okay, yep, thank you. So whether just goes.
Which I think was Mr. Dunlop's suggestion anyway.
I actually suggested something slightly different, but it's the same thing.
Yeah, well, I think both of you have, and now we know what there was intended. Yeah, fantastic. Thank you.
So the additional authorities.
Yes, the additional authorities here.
Are they sort of dealing with a number of issues, or?
Yes, dealing with a number of issues
Okay.
that arose yesterday, and in respect of questions posed by the court.
Thank you. And you've given them to us in the order in which you're going to deal with them.
Well, what I thought I'd do is just take the court through them,
Okay.
having handed them up so the court knows what they are.
Yes.
So the court asked the question about whether what does wrong mean in these circumstances. And although I don't take great objection to the first instance authority handed up by my learned friend, the judgment of Mr. Justice J in the GMC and Stone case, indeed, we place reliance on paragraph 33 of that. But we also got printed off the case of Crown against Chief Constable of Greater Manchester Police and another. And at paragraph 64 of that judgment, Lord Justice Carnwath looks at the question of what approach the court should take in the question of an appeal against an articulate balancing exercise or proportionality finding. I don't know if the court just wants to read through paragraph 64.
Yes.
That's broadly consistent with the approach taken in Zelinsky on extradition appeals.
Yes, and reflects the approach taken by the Supreme Court in the B family case in respect to the proportionality exercise, and reflects what Lord Justice Laws said in Subesh about finality in litigation and courts not indulging in reviewing matters where there's no obvious where there's no error to justify it. That's all I had to say about the test.
Right.
Unless the court wanted any more from me.
Thank you.
The next case, case the court should have in its file is Mahad and the entry clearance officer.
Yes.
And I put that in, although Mr. Dunlop has indicated to me it's not in dispute, that what the proper approach is to the construction of the rules. And I put it in because it's my submission that Mr. Dunlop, QC for the Secretary of State, was seeking to indulge in some speculation about policy matters behind the rules. And paragraph 10 of Mahad is the paragraph where the court encapsulates what the proper approach is. The particular part that I refer the court to, it's at B on page 55 of the judgment. The rules are not to be construed with all the strictness applicable to the construction of a statute or a statutory instrument, but instead sensibly, according to the natural and ordinary meaning of the words used, recognising their statements of the Secretary of State's administrative policy. ECO's counsel, I think that was Giovanetti, QC, readily accepted that what she meant in her written case by the proposition, the question of interpretation is what the Secretary of State intended his policy to be, was that the court's task is to discover from the words used in the rules what the Secretary of State must be taken to be intended. That's an objective.
Yes.
Do you accept Mr. Dunlop's proposition yesterday that the rationale behind 276 ADE was to encourage good behaviour of persons illegally present?
I accept that may be one rationale, it's one legitimate conclusion to draw, but for the reasons I submitted yesterday, what the tribunal did was say in terms, I think it's at paragraph 131, it's open to AM to say that length of residence is a material factor. And we have also handed up, I understand it, a copy of this statement of changes in immigration rules. That should be in your pile. I'm sorry if it doesn't come next in the order. Now, the court asked me yesterday when the new sort of shift in the rules seeking to incorporate questions of Article 8 within the terms of the rules themselves. And this is the document which was put before Parliament which introduced those statement of changes.
And if I'd read the whole of Hashem Ali, I'd have found the answer in there as well.
Oh, yes.
But it's very helpful. Thank you very much.
But we'd also flag up that the explanatory memorandum at paragraph 7.7, which is towards the back of the document.
7.7.
Yes, at the back of the document.
Yes.
Sets out, in my respectful submission, what the significance of the 20 years continuous residence was. Basically, it was an increase from the previous recognition that 14 years was a yardstick. The rules increased the yardstick to 20 years. And that, in my respectful submission, is significant. It's not determinative, and the tribunal didn't treat it as such. They were entitled to, in my respectful submission, treat the accumulation of 20 years as material. Now, yesterday when making submissions about other circumstances in which the Secretary of State has been required to recognise that notwithstanding the Secretary of State's ultimate intention to remove a person, it may be necessary to grant leave in the meantime. And there were 3 cases that I had referred to in submissions, one of which was highlighted in Lord Justice Haddon Cave's judgment in RA Iraq, which I took the court to yesterday. I'm not planning to go there again today, unless the court wants me to. Rahman was the case in which Lord Justice Richards and Lord Justice Ricks granted permission, and my submission was that that had not gone to a substantive hearing because leave had been granted. Now, I must clarify, and should clarify, that that was a case in which there were also, there was a relationship with a British citizen in play, and although I've asked Turpin and Miller for the order if they can track it down, I'm unable to say that it was definitely the limbo basis on which the leave was granted rather than the relationship. I would need to have a look at it.
So there were other factors in play.
There were other factors in play.
Yeah.
I don't know if the court can recall, but there was a time when the Secretary of State used to make a decision refusing a human rights application or an application for leave, and then there was a sort of a hiatus while they decided what they were going to do ultimately with the person and whether they were going to remove them or not. There was quite a lot of litigation about what should happen in the meantime, and I think that case arose
in those circumstances, yeah. Because the courts then decided that the Secretary of State could just rely on the person going voluntarily.
I'm sorry?
The Secretary of State, the courts decided that the Secretary of State was entitled not to serve deportation orders in every case.
Yes, that's right.
Could rely on people going voluntarily, regardless of whether they did or didn't.
That's right. As part of the picture, yes. And ultimately, the regime changed, and that sort of issue went by the wayside. So the other 2 cases that I referred to yesterday, one is called MS Ivory Coast, which the court has. And one is called MS India and MT Tunisia. The MS India and MT Tunisia is the restricted leave case that I briefly told the court about yesterday. It's a long judgment, and it's fair to say that the substance of the reasoning is not something that needs to trouble this court. But the reason I make reference to it is because in that case, it was being argued in cases where there had been a determination that an individual was not removable by reason of Article 3, and the Secretary of State had a policy of granting short periods of leave called restricted leave under the restricted leave policy. The policy had to recognise that there would come a stage at which leaving that individual on this sort of turnaround of 6-monthly leave, or not granting indefinite leave to remain and recognising that in truth the person wasn't going anywhere, was unlawful. And so the argument in the case evolved around what Article 8 required in respect of ensuring that the policy required decision makers to take into account all material factors when deciding whether the time had come to end restricted leave and go on to some other form of leave, or whether longer periods of restricted leave should be given. And Lord Justice Underhill gave some... They held that the policy itself was lawful. It had sufficient flexibility in it to deal with those issues. That's fundamentally what they found. But they did give some guidance about the circumstances that the court would be wanting to take into account when faced with an application from an individual that the time had come for restricted leave to end and the individual to go on to a more permanent form of leave. And so, in particular, if we look at I'm just trying to forgive me, I should have flagged this up before I came, but I wasn't trying to get these copied and hadn't marked up this copy. Yes, if we start at 106. So 106 is a reference to a case of Cardi in which Lord Justice Richard, faced with another restricted leave challenge, said, yes, the decision in this case is compliant with Article 8, but again, there will come a point at which it will be no longer reasonable to keep somebody on restricted leave. So that was the starting point. But in that case, the Cardi case, it hadn't been reached. And then at 115 onwards, the court looks at the sorts of factors that the court will need to take into account when dealing with such an application from an individual that that point has been reached. Notwithstanding, and this was a consistent theme, the Secretary of State's wish to deport the person, the wish to continue to progress removal. So at 117, the court identifies cases where there's such a risk to national security that that point will never be reached. And then the court deals with the situation where there's no foreseeable likelihood of removal becoming possible at 118, being a material factor. And then you see the Secretary of State's position that even in cases where, notwithstanding the restrictive features of restricted leave, private life had been built up, that there should be a test of exceptionality in considering whether or not ILR should be granted. And at the bottom, 120 onwards, Lord Justice Underhill identifies some factors which he says would be material to the assessment. 120, the first is length of residence in the UK. Bottom of 127.
And this is talking about, well, the case is about
Yes.
indefinite leave. Is that right?
Yes, this was an argument over
Yes.
that. In both these cases, the individuals were saying the time has come to take us off restricted leave and put us
Yes.
on indefinite leave.
Yes.
The cases were unusual in one sense because the policy was new, but the fact of their presence in the UK was old. So the court was looking at a situation where private life or other matters, private life, family life, had been built up during a period where the policy wasn't in existence, and this policy was being applied sort of prospectively, as it were, in those circumstances. But the court still held it was lawful.
Yeah.
It was lawful to maintain that intention to remove and send out the signals, etc., that intention demonstrated, and the UK not becoming a shelter for war criminals and that sort of thing.
It's interesting that at letter D on page 428, the 20-year point is taken, and it's suggested there that the rule provides some context.
My lady is ahead of me, as always.
But hardly that.
I was going to draw the court's attention to. And then a question of the gravity of the conduct at paragraph 121. In my respectful submission, Lord Justice Underhill is simply expressing that which the upper tribunal has expressed, which is that it's a context. It gives some context to the period of time. They don't do any more than that.
So the net effect of this is that they stayed on the restrictive leave, and
Yes.
no doubt have challenged that again.
Mr. MBT got a year in the end on the last tranche of leave, I think. I'm not representing him anymore.
No.
And MS, I think, went on to a longer period. But both, yes, in both cases, the court didn't say that it wasn't a legitimate prospect for the Secretary of State to persist in her wish to remove. And the same applies here. There's nothing about the upper tribunal's judgment in this case which acts on a fetter on the power to remove, because the court hasn't found or been asked to address the point that Article 8 private life gives this individual protection from removal or any right to remain in the UK. What the tribunal has done purely is look at the administrative question of what happens to him in the intervening period.
And I think yesterday you started off with the proposition that you accept it would be lawful for the Secretary of State, obviously it's for the Secretary of State, to meet the declaration by giving restrictive leave.
Ooh. I wouldn't want to positively encourage the Secretary of State.
No, you obviously want ILR
yes.
and all the rest of it.
Well, no, and I certainly don't go that far either. Restrictive leave is a form of leave for people who do pose a very serious risk because they've been excluded from the convention or they're guilty of very serious crimes. I'm not saying that restrictive leave, but if the Secretary of State were to say we're going to give you 6 months DL and we'll look at it again in 6 months, I couldn't complain with that. But the reason I can't complain is because as the case law establishes, once the court has made a conclusion about a person being entitled to some form of leave, it's wholly within the gift of the Secretary of State to decide what form that should take. And the upper tribunal hasn't trespassed on that principle. So there were a number of other factors that the court took into account, but I don't think Article 8 type factors that might arise in those sorts of cases. But the court's picked up on the essential aspects of the case that I wanted to discuss. And importantly, there's nothing about the grant of leave itself, in a case such as this, which would prevent the Secretary of State from pursuing ultimate removal or deportation. And so much is recognised in the restrictive leave policy itself. The other case I wanted to take the court to is the MS Ivory Coast case, and that was a different situation that I'd flagged up yesterday. That's a case in which, where there are parallel family proceedings, but let us say that an individual is facing deportation and he wishes to rely on his relationship with children, and the court, the family court, is seized of the issue of what that relationship qualitatively consists in and where those best interests of those children lie, then there's sometimes an issue about what position that individual should be facing deportation pending the conclusion of those proceedings. And the position of the Secretary of State, which was challenged in MS Ivory Coast, was that persons in that position should be placed on temporary admission. And what the court decided in this case, and I accept that it's a completely different situation to the instant situation. What the court decided in this case is that leave should be granted rather than temporary admission in recognition of the fact that if the Secretary of State had proceeded with removal pending the conclusion of the family proceedings, that may well breach Article 6 taken with Article 8. And we see that analysis forgive me, I had, I'm afraid I had highlighted my other copy. Yes, so it's the essential reasoning is at 61 onwards. I don't know if the court might already be there. And in that case, it wasn't the existence of a particular Article 8 circumstances as arise in this case. It's a factually different case. But at paragraph 65, the court notes that Mr. Nichols' submissions that the hypothetical possibility of removal still exists, even where the Secretary of State has indicated that she didn't have plans to remove, pending the resolution of the family issue. Sorry, at paragraph 65. And then at paragraph 72, the court reasoned that the appellant in that case was entitled to have determined whether removal from the United Kingdom with an outstanding contact application would breach Section 6 of the Human Rights Act. That question was capable of resolution one way or the other. What was not appropriate was to leave her in this country in limbo with temporary admission and a promise not to remove her until her contact application had been concluded.
So they remitted it to the then upper tribunal or equivalent to determine the issue that they'd not, namely whether removal
Yes.
would breach.
That's right, and I think the issue was determined by a constitution of the upper tribunal chaired by Lord Justice McFarlane, but the judgment was written by Mr. Justice Blake, and that's a case called RS India, where they sort of flesh out those. I can provide that to the court if necessary. But the reason I'm flagging up that is because it's another situation where ultimately deportation may pertain. In the interim, court said some form of temporary leave has to be granted.
Well, they didn't. They remitted it to
yes.
the upper tribunal to decide for itself whether to grant.
That's right. I will provide the copy. I will provide RS India. I should have done that. I was trying to just go to the heart of the rationale. But yes, I'll provide a copy of RS India to the court.
Thank you.
So in essence, what we say that what the upper tribunal has done in this case is not as out there as the Secretary of State would have this court believe. It's a recognition that in some particular circumstances, I think it's right to say that the tribunal has identified these circumstances as very particular, as compelling, as exceptional. It may be necessary to grant, to regularise the status of an individual in the meantime, notwithstanding an ultimate intention to remove or deport. Now, I quite wrongly took the court yesterday to the wrong bits of Hesham Ali. I think the court might have gone away and read it. I can just flag up briefly that the essence of the submission I'm making is the same. In Hesham Ali, the question being, I paraphrase it, the question being addressed by the court was, is it lawful to have aspects of Article 8 considerations set down in rules from which then Article 8 considerations should be considered? Answer, yes. What were the immigration rules a complete code such that the court didn't have to, in an appropriate case, go outside the rules and look at other factors? Answer, no. And I'll just take the court to Lord Reid. And if the court's had a look at the judgment, then we can go straight to paragraph 50, page 260 and 261 of the authorities bundle. And this builds on what the court described as the established method of analysis when it comes to Article 8 cases, paragraph 49, and says, in summary, therefore, the tribunal, this is 50, bottom page 260, The tribunal carries out its task on the basis of the facts as it finds them to be on the evidence before it, and the law is established by statute and case law. Ultimately, it has to decide whether deportation is proportionate in the particular case before it, balancing the strength of the public interest in the deportation of the offender against the impact on private and family life. In doing so, it should give appropriate weight to the Parliament's and the Secretary of State's assessment of the strength of the general public interest. Pausing there, what the upper tribunal had identified in this case was that a different public interest arose than the public interest that arises in deportation cases. Because the upper tribunal was not ruling on whether deportation would be lawful. It was not making a ruling weighing up whether the private life rights in this case gave rise to a right to remain or protection from expulsion, a right to stay. They weren't dealing with that question. They weren't touching it. The only question related to the public interest against regularising the status of this person while something is done about the Secretary of State's ultimate intention to deport, which the Secretary of State describes as remote.
Well, the intention's not remote. The possibility of deportation.
That's fair. That's fair. But in essence, it's important to note that when I'm drawing a distinction, I'm doing it because the upper tribunal is deciding a different question. So in that sense, the balancing exercise that the upper tribunal took into account undertook was orthodox. It took into account everything relevant. It weighed it all up. Took into account what the rules say. Noted that it was dealing with a different order of public interest. If it's helpful, we also have Lord Justice Underhill in HA Iraq, which is a sort of a post-Section 117 case at Authorities Bundle, page 513. Also reviewing what the proportionality exercise entails. This was a case looking in a bit more minute detail on the impact of Section 117 in deportation circumstances. So it's not, as I say, it's not directly dealing with the circumstances that we're dealing with here. The case that deals with the circumstances that we're dealing with is RA Iraq. But it's important to note that even in following Section 117C, the court has reiterated, and we see this at 527G, so Authorities Bundle 527 at G, in carrying out the full proportionality assessment where it is necessary, where the exceptions do not apply, facts and matters that were relevant to the assessment of whether either exception applied are not exhausted if the conclusion is that they do not. They remain relevant to the overall assessment and could be sufficient to outweigh the public interest in deportation, either if especially strong by themselves or in a combination with other factors. So what the Lord Justice Underhill is saying there, that one doesn't say, well, you can't make it under the rules, so we don't take into account those factors that you rely on. Everything goes into the mix in an Article 8 assessment outside the rules. And that is what the tribunal did here.
This case has gone to the Supreme Court, hasn't it? But I think on a probably different point.
Yes. I
think it's on the unduly harsh.
Yes, on the meaning of unduly harsh.
Yeah.
Yes, that's right. I hadn't understood that anything that in that reasoning had affected this.
Well, no, it hasn't been heard yet.
Oh right.
So that's no.
But I'm sorry.
Pretty sure it's this one, isn't it?
This has gone to the Supreme Court on the whether or not they were entitled to take the approach that they did in the light of the Supreme Court's own judgment.
Ah.
I think.
Oh right. Well, the court's ahead of me then because I wasn't aware that there
this is yes. If you look at the held note on page 514, KO and Secretary of State for the Home Department applied, and it's gone to the Supreme Court on the basis of whether it actually was applying KO Nigeria or actually purporting to apply it but not really doing that justice. But I don't think it undermines the point, and indeed I don't understand Mr. Dunlop to say that the court shouldn't have taken into account all the relevant factors. What he says is that the court made errors along the way, in particular by overemphasising the 20-year point.
Right. So may I just turn my back for a moment?
You also handed up long residence.
Oh, the rules.
Yes.
I had said yesterday that I would provide a copy of the rules.
Right. Okay. So it's simply giving us a copy.
Yes, the court can see.
So we can see the whole
context,
lot.
And it shows the heading is long residence.
Yes, and then the sort of heading under that is private life.
Yeah.
Okay.
So, but that, taken with the statement of changes and the explanatory memorandum, makes it clear that.
Thank you.
20 years has some significance. Yes, I've just got. I wanted to take the court to the part of Stone that we place particular reliance on, which is the.
This
the
Mr. Justice
Stone.
Jay's judgment.
Yes.
Yeah.
Now this, I haven't taken the court to AH Sudan. It's in the court's bundle. It's the case where Lady Hale. It's in the court's supplementary bundle of authorities. I'd better turn it up just so that the court.
It's divider 1.
Yes. So it's paragraph 30 is the paragraph. And it was the final sentence of paragraph 33 in the GMC case to which on which Mr. Dunlop places reliance, which is that, as a general rule, the clearer it is that the tribunal has covered all relevant considerations, the harder it will be for this court to intervene. This is because the issue will tend to dissolve into one about weight and expert evaluation, which I respectfully submit is precisely the pitfall that the Secretary of State is inviting this court to fall into in this case. Excuse me. Moylan Jr. is reminding me that this is a very long determination by the Upper Tribunal and that we've only dwelt on parts of it. And it's important to note that the Tribunal undertook a very thorough review of the facts. And in particular, at the beginning of the judgment, paragraph 2 onwards, it's quite clear that the Upper Tribunal, without taking the court through all of it, undertook a very careful analysis of the facts in this case and concluded that notwithstanding some unsatisfactory features of the material, that it didn't consider that it had a proper basis to go behind the findings of credibility in this case. But notwithstanding that, having taken all that into account, taking into account the Secretary of State's position on the remoteness of removal, and weighing all those factors into account, reached the conclusion that it did. So it just can't be said in this case that the Upper Tribunal had failed to take into account the bleaker aspects of, and that the Secretary of State is wrong to invite this court to harness on a couple of paragraphs when what's required is a review of the judgment as a whole. May I turn my back just for a moment? Oh, yes. The court asked about where is it set out what this individual has failed to provide by way of information. I'm not able to accept or adopt the submissions, the latest submissions made by, because they are submissions in my respectful submission. But there are two documents that were recently disclosed. I took the court to one of them yesterday, by the Secretary of State, where the Secretary of State's own officer has undertaken what I would suggest is an even-handed and measured assessment of the information that this individual has provided. And the first of those documents is in the supplementary bundle at 124.
Yes, that's the one we saw yesterday.
Yes, and the second of those documents is a report called the Tamani Report, and that begins at 170.
There's a fact date on this of the 25th of January 2019.
I understand that to be when it was disclosed,
Right.
or around that time.
Yeah.
But the report itself, I understand to date from 2003. I'll just turn my back. Yes, Mr. Carnick is nodding.
But you're not now challenging any of the findings of fact made by the Upper Tribunal?
No, exactly.
No.
I'm not.
No.
But it's right to say that there are some unsatisfactory features of the history of the case, and it may be that those features, when the Secretary of State reflects on them, will assist the Secretary of State to reach a view about what the way forward should be, including perhaps approaching the Belarus embassy and asking what their position is and why. But in any event, that material was before the tribunal, and the tribunal had regard to it. And as I say, I don't invite the court to interfere with the conclusions of fact. It's fair to say in my submission that the tribunal looked at everything, properly directed itself as to the matters which it had to take into account and give weight to, and concluded in this highly exceptional case, for reasons which were open to it, that this case tipped over the edge where some form of leave had to be granted, without, of course, being prescriptive about what form that might take.
Yes.
So I wanted to make sure that the court was aware that those are the two documents which I say set out with some clarity the history, the identification of history. May I just turn my back for a moment? Mr. Mikkel informs me that we also place reliance on the interview records. There's nothing wrong with those as far as we're concerned. They are handwritten and a bit dense. I wasn't saying that the court needed to read through them in order to decide this case, but they are there, and we do say that they contain some information which indicates that his history and address were given early consideration, and he provided that information as contained in there.
Yes.
The court was wanted to know about the working history, whether there had been previous right to work granted. There was right to work granted in a short period between the 8th of November 2010 and the 10th of December 2010. But I'm unable to put any flesh on the bones of exactly what the rationale was, save that...
Sorry, 8th of November 2010 and?
To the 10th of December 2010.
Thank you.
Save that, as at the 10th of December 2010, the Secretary of State decided that he should no longer have that. I think it would have been in connection with a decision they made at the time, but I don't think the court needs to be troubled about that. In any event, the Secretary of State has never offered, didn't offer to the tribunal the right to work as an alternative. Oh, right. Okay, it was relating to the reception directive, which is no longer in force. Now, Mr. Dunlop, for the Secretary of State, has indicated that he wishes to make some submissions on the case of Rupia, and I'm wondering if the court might indulge me in allowing me to hear precisely what those are before I respond.
Yes, thank you. That's it?
Unless I persist further. Thank you.
Thank you very much. Yes, Mr. Dunlop.
My Lords, can I begin with the answers to the questions?
Yes.
Just to check that they do adequately answer your questions. Do you have hard copies of those? If not,
yes.
I can pass. Thank you.
Yes.
So if I begin with question 1, when did AM fail to provide information or physical data? What we've done here is we've set out the various ways and occasions in which, according to the evidence and the findings, AM has failed to provide information or physical data that is true. We've added the page references to the evidence and to the findings. I particularly emphasise the point we've made in paragraph 6, that consistency in this case does not indicate truth, and that is reflected in both the findings and the subsequent evidence. So we have at 6 Roman numeral 1 a finding by first-tier Judge Pula that it's likely that the appellant has failed to provide accurate information to enable the Belarus authorities to trace him or find any record of him. I also rely on point 2. These notes my learned friend herself relies on point out the fact that some of this key biodata is contradicted by the other evidence, such as the fact that there's no record of someone of his name, of his alleged date of birth in his alleged area, and his family name is not registered in that area, and the primary school he's consistently given, there's no record of him there. And then there's also the fact that subsequent to these reviews, there has been a further contact with the Belarus authorities. And this anticipates a question my Lord Justice Dingemans asks about what was the result of that. And we've set out there and given you the page reference for the result of that, which is the Belarus authorities coming back and saying, obviously, this person gives false information about himself and tries to hide his identity. So the conclusion of all of that is that the findings of Pula were right, the findings of this upper tribunal were right. We're talking about someone who has hidden his identity by giving false information as to basic details. Name, date of birth, primary school, so on. And there is no excuse for that in his being a vulnerable witness now. So what is the basis, question 2, for saying he could be removed if he provided truthful biodata? Again, we've explained, we've quoted there the particular findings. First, the finding of Judge Pula, and then second, how the Court of Appeal interpreted Judge Pula's finding and Judge Pula's decision in the round. And ultimately, they concluded that the suggestion by AM that he would still be refused, even if he told the truth, was wrong. In other words, it was his failure to disclose his identity that was the causative reason for him being refused entry to Belarus. And that finding was upheld by the upper tribunal, and my learned friend rightly doesn't seek to reopen it now. Question 3, we're going to come back to you. Question 4, we set out all we know about, all we can find about the mother and the brother. The essential point is, on his own case, he's lost contact with them. And he doesn't know where the brother is.
Yes.
We have done one relevant check, which didn't find that surname anywhere in Vetka, which is the place he was born and grew up. Other than that, we've got no further information to give the court.
Thank you very much.
So, thank you, Moylan. Now, with some diffidence, I offer a note of reply that I could hand up if you think it would be helpful, that I drafted last night. It might enable us to finish quicker, but...
Yes. Thank you.
Road is this?
And does Miss Weston have
Yes.
Thank you.
The odd bit of adaptation.
Thanks.
So the first submission that I wish to respond to is the one on the first page in italics. The submission by my learned friend that this is it's important that this is the context of this is not a route to settlement, And this is a similar sort of context to the situation where someone in ongoing family proceedings may be given a short period of leave outside the rules while the proceedings continue, or the restricted leave cases, where someone can't be removed because of Article 3, but the Secretary of State hopes that things may change in the future. And you see our submission here that this overlooks a key distinction between this case and those examples. In this case, it is within AM's control whether he can be removed. The person in family proceedings, the person A, doesn't have that kind of control over when those proceedings conclude. And likewise, the person with restricted leave only has restricted leave because of the risk of torture or inhumane or degrading treatment on return, not in control of that. So, put another way, granting leave to these examples, person A or person B, doesn't diminish the possibility of ever removing them at some point in the future. By contrast, granting leave to AM does diminish the prospect of ever removing him. Because effectively, on the basis of the findings I've just been taking you through, the only real possibility of removing him is the possibility that eventually he discloses his identity. Eventually, the difficulty of living without status in the compliant environment may lead him to tell the truth about who he is and what his date of birth is and so on. If he is granted leave to remain, even for a short period, then that possibility is extinguished. Why would he then tell the truth? And so my own friend was wrong when she submitted this morning. There's nothing about a grant of leave that would prevent removal. In practice, a grant of leave would extinguish that possibility of removal. And that's a key consideration that simply doesn't feature in the Upper Tribunal's Stage 4 balancing. So that's my response to that first submission.
Do we find that reflected in the submissions made below?
I'm not sure off the top of my head. I'd have
Because if you say it's not a point taken into account, if it wasn't a point that was advanced, then somewhat diminishes the force of your submission.
Yes, although what I will say when I come back to RA is that the fact that this is a sort of self-induced limbo is a really key consideration on the face of the case.
I understand that. I just wanted to know whether you're saying the key consideration does not feature in the Stage 4 part of the exercise, and I was just wondering whether this specific point was made. That's all.
I'm sorry to say that I don't know for certain. I'd have to check.
Okay.
So the second submission that I wanted to respond to was the submission that sections 117A to D are fulfilling a different function, a different mischief. And I don't accept that. Can I just take you back to section 117B? So take you to the authorities bundle.
Sorry, which section? 117?
117B, so
B.
page
Thank
6
you.
of the authorities
Yes.
bundle, behind tab 1. And I just wanted to highlight in section 117B2 and 117B3, there's reference to persons who seek to enter or remain. And so those considerations, for example, are focused on persons seeking leave to enter or remain. So that would include people applying for leave to enter from abroad or for short-term leave to remain. It's not just about removal. And if there were any doubt about that, then Rupiah, which is in the supplementary bundle of authorities, would resolve that. And Rupiah is behind tab 8 the supplementary bundle.
Yes.
And there are just two paragraphs I wanted to take you to. The first is paragraph 36. You'll see that there's quoted, indented there, a passage from Lord Justice Sale's judgment below, which is said by Lord Wilson in the sentence afterwards to be clearly correct. And what Lord Justice Sales had said was that sections 117A to D are intended to provide for a structured approach to the application of Article 8, which produces in all cases a final result which is compatible with and not in violation of Article 8. So it's meant to apply to all Article 8 immigration cases, not just to some sort of subset. And the second point, second paragraph I think I should take you to explain how that's achieved in a sort of section 117B 4 to 5 case, is paragraph 49. Just the end of paragraph 49, picking it up around C on page 5550.
Yes.
Lord Wilson says, just before the indented quotation, it's impossible to improve on how, in inevitably general terms, Lord Justice Sale, in his judgment, described the effect of section 117A2. Although a court or tribunal should have regard to the consideration, little weight should be given to private life established in the specified circumstances, it's possible without violence to language to say that such generalised normative guidance may be overridden in an exceptional case by particularly strong features of the private life in question. And it's my submission that, our submission, that in this judgment, the upper tribunal does not identify particularly strong features of AM's private life. Private life is, of course, not just about the length of time spent in the country, but what the person does with that time. And on the upper tribunal's finding, AM had not used his 20 years in the UK to build up a strong private life. On the contrary, he was not socially or culturally integrated, not socially and culturally integrated in the UK. And there's one point, I should qualify the way I put it in paragraph 8 of the slide note, but there's certainly at one point in the upper tribunal's reasoning where this almost appears sort of back to front, because when they're looking at the question of deterrence in paragraph 136, they count his lack of private life, his homeless and rootless lifestyle, as a factor that effectively weighs on his side of the balance, diminishing the damage to the principle of deterrence. But really that, for reasons I've said, shouldn't have damaged the principle of deterrence, and it ends up sort of being placed on the wrong side of the scales, because the absence of a particularly strong private life was something that was highly relevant and should ultimately have been one of the reasons why his claim should have failed.
If you finish 117B, can I just ask you about your first submission, which in reply, which was to the effect that the tribunal had ignored in the evaluation the fact he was the bar, and ask you just to address paragraph 133. They say that the public interest can't be said to have been extinguished. And it's the applicant's refusal to be candid about himself. Now, no doubt you would like them to have been stronger, but it seems to me difficult to say that that's not taking it into account in the stage 4 analysis, given the heading before paragraph 130.
Yes, but what they don't acknowledge in paragraph 133 is the point that granting him leave to remain will extinguish any possibility of him changing his mind and being candid.
Well, they've grappled with the fact of whether he's going to change his mind anyway, and had taken into account the concession made on behalf of the Secretary of State that was remote anyway. So it wasn't a case where keep him here and he's going to change his mind. Everyone accepted wrongly that this man has just refused and will continue to refuse. So that's the context in which you're doing it. This isn't a situation where it's like you or me put under pressure making a rational decision. This is a person in a different situation.
Well, I don't quite accept that analysis because when they're looking at the common law and whether removal is impossible, they recognise that it's not impossible and there is at least a remote possibility of removal. And that remote possibility is the remote possibility he may ultimately change his mind.
Yeah, but
and that
just this enables me to put the other point to you, which is yes, but when you've had 20 years of someone being as immune to proper principled pressure exerted by the Secretary of State on him, then there does come a time when one can say, well, it's remote, and that is a factor which might have carried the day in many other cases, but not in this particular case.
Well, I entirely accept that the possibility is remote, and the fact that he's maintained his position for 20 years shows it to be remote. It's nonetheless a possibility, albeit a remote one, that is effectively extinguished by granting him leave to remain.
Thank you. Sorry to interrupt.
No, not at all. It's very helpful to hear my Lord's thoughts. So if I then move to the third submission, which I think my learned friend has very helpfully sort of neutralised, as it were, with her very appropriate concessions. Rahman really doesn't help anyone. We've made 2 points in paragraph 9. The first is that the fact that leave was granted doesn't mean that it had to be under Article 8. And the second was it was materially different for a number of reasons, not least the fact that it was a family life case, someone who was married to a British citizen, it was accepted, on the permission decision it's accepted, couldn't be expected to relocate, and they were stateless through no fault of their own, they were Palestinian. And then my learned friends helpfully clarified that MS, that's not a sort of actual limbo case, but a restricted leave case.
Sorry, which MS?
Well, neither of them. It's just that, my Lord, you yesterday suggested there might have been 2 examples where leave had been granted, and you said Rahman and MS. I don't know which of the MSs you had in mind, but actually none of the MSs.
Well, is the MS in our bundle, which I think...
Well, we've got Ivory Coast and we've got the MS India.
Well, I think it's the MS that's called a number of different things. It's divided 12 of the authorities bundle. You see, if you look at the editor's note on page 490, the appeals were relisted. The third appellant withdrew her appeal due to a continuing delay, and the first appellant was granted ILR.
Right.
So that was that's another MS. So in fact, we've got 3 MSs.
Yes.
And this is the one that I think is sometimes referred to as by a different name, and is referred to by a different name in RA Iraq.
I don't. Sorry, I thought that you'd been referring to the other MSs my own friend had referred to, so I haven't read through all the details of this case, but I note, just skimming the head note, that the MS in this case was also a Palestinian, and therefore presumably actually stateless. What I really wanted to confirm, as it were, is the point made in paragraph 11, which I don't think is contradicted by any of the MSs or Rahman, which is that there is no authority, so far as any of us can discover, either in the UK or in Strasbourg, which has ever held that Article 8 requires a grant of leave to a person who's built up a private life in a member state by voluntarily thwarting removal and as a result living unlawfully for a long time in that state. And the closest parallel, except that every case has different facts, but the closest parallel one can find is the case of Hamza. And I think it is helpful to go back to the passages in RA that my learned friend took you to about Hamza. And that's at tab 18 of the authorities bundle. So if one turns to paragraph 44, page 504, one has set out there the decision of Mrs. Justice Simler, as she then was in first instance, we'll come back to that because RA, Lord Justice Haddon-Cave comes back to that judgment later on when he's giving guidance. But if we can just move on to what was said on permission, paragraph 47 and 48. Lord Justice Underhill, in the permission hearing, makes an observation, or makes a few observations, and particularly paragraph 48, a key consideration in refusing permission was the fact that voluntary departure is still possible, and any state of limbo they find themselves in is self-induced. And that was critical to the outcome of that case. The Court of Appeal didn't suggest that was wrong or an overemphasis, and on the contrary, when Lord Justice Haddon-Cave gives guidance, it's very much in line with that approach, that if the actual limbo is self-induced, that's highly material, often determinative factor. And so if we move on to paragraph 67, stage 3, and the very last criterion identified there is whether the impossibility of achieving deportation is due in part, and I stress in part, to the conduct of the individual. In a case like ours, where it's that non-cooperation is been found to be causative, then that factor is all the more important. And what's striking is that when Lord Justice Haddon-Cave sets out the guidance on how the balance is to be struck, he finishes it with the warning from Mrs. Justice Simler and Hamza, paragraph 72, and in particular, the warning that one shouldn't create perverse incentives to obstruct removal, rewarding those who fail to comply with their obligations as compared to those who ensure such compliance. So, to some extent, I think my learned friend's probably right. I probably didn't need to go to Dragon or Ramadan, because it's all here clear enough in RA. That's why I don't say there's anything wrong in the guidance in RA, but I do say it hasn't properly been applied. Perhaps paragraph 13, my speaking note, may put the point too strongly, but what I do say is that there hasn't been a proper consideration of the impact of this case on the deterrence principle. Too much focus on the particulars of this case, not enough on the impact, the possibility of creating a perverse incentive to obstruct removal.
Can I just check one point of detail while we're on this? If you go back to paragraph 55, sorry, of 37, where it says R, AR, and Secretary of State,
Sorry,
that I think is in fact the reference to the MS.
Sorry, when you
Paragraph 37.
37 of RA.
Yeah. Is the MS that we've got in the bundle, isn't it? At 12, I think.
Yes, it has the same neutral citation, so it must.
Yeah.
So then I move on to the fourth submission, which is responding to my learned friend's submission that in approving the rules, Parliament has endorsed the 20-year mark as having significance. And she also said one of the rationales might be to provide some sort of incentive. The rationale can encompass a number of aspects. And what we say about that is that 20 years does have significance in the rules. It's the point when otherwise compliant illegal migrants may obtain the benefit of the rules. But that doesn't mean, as the upper tribunal thought, that 20 years in life in the UK has special significance under Article 8 in cases outside the rules. My learned friend rightly accepts that at least one rationale of 276 AD is to incentivise cooperation and good behaviour. That is apparent applying the principles she cited today, looking at the wording of the rules. She suggested there might be other aspects to the rationale, but I didn't hear a clear specification of what those were. Certainly nothing that could have justified the upper tribunal putting the rationale of 276 AD on the AM side of the balance rather than the Secretary of State side of the balance. And nothing that Lord Justice Underhill said in the passage you were taken to this morning is any different to this. He doesn't say anything about what the rationale of 276 AD. He uses the phrase some context, which is very different from saying that the rationale supports a grant. My Lord, turning to page 5 of the reply note, this is an answer to your question about whether there's an analogy to extradition cases. And not being very familiar with them, I chose a different analogy, the context of appeals against regulatory tribunals. The reason I highlighted the reasoning of Mr. Justice Jay is really to explain why I was somewhat hesitant to accept that this is just about weight, because he draws a distinction in that case between a situation where a tribunal has failed to grapple with relevant policy, relevant guidance, and a situation which dissolves into mere arguments about weight. So that's why I say it's not really just about weight. It's about misdirecting themselves as to a key rationale. And a closer analogy is the case of Hesham Ali, which my learned friend has now very helpfully taken you to the majority judgment of Lord Reid, where he in effect says that appropriate weight needs to be given to the immigration rules and where Parliament and the Secretary of State struck the balance. And I submit that a tribunal that's misdirected themselves as to the rationale of an immigration rule and relies on that misunderstanding cannot have given appropriate weight to where the balance is struck. As for the result of the telephone conversation, I think I've dealt with that in the note, which I addressed earlier and explained at SB 115. We have the Belarus official saying he's given false information and tried to hide his identity. Paragraph 19 of the speaking note, I just wanted to clarify the extent of my sort of, if you like, concession. So it's not, I don't appear to have gone too far. what I accept is that given what's an issue in this case, the distinction between positive and negative obligations is really one of form rather than substance, not something that matters. There are other contexts where it can be material distinction, can matter, and FWF provides an example. In a case where there's a dispute about whether something was in accordance with the law, then it matters, but we're not in that kind of case. And so then, finally, I come to a sort of almost a wrap-up submission, responding to the point made by my learned friend, reliance on A.H. Sudan and the expertise of the upper tribunal, and particularly an upper tribunal including the president. And I understand and recognise that this court be slow to decide that such a tribunal reached a wrong conclusion. However, context is everything. There are some decisions that need more careful scrutiny than others. This was a decision breaking new ground. The first time any court has ordered a public authority to grant leave to remain to someone with private life built up through self-induced limbo, as it were. And so it is necessary to scrutinise the decision very carefully and make sure that the upper tribunal had regard to all relevant considerations and only relevant considerations. And that's where we say, that's where our grounds 2 and 3 come into play. And we say that they misdirected themselves on the rationale, placed it on the wrong side of the balance, wrongly thought 20 years was an important yardstick for the purposes of Article 8, didn't properly engage, I should say, in the Stage 4 section of the decision for the fact that this is self-induced limbo, and connected to that, didn't properly consider deterrence and the principle identified in Hamza and RA that notwithstanding the unhappy personal circumstances of this particular individual, granting leave in a case of self-induced limbo sends out a damaging message, rewarding non-compliance and undermining the ability of the Secretary of State to deter non-compliance. Thank you very much. Is there any?
Can I just ask one
Yes.
further question? Your sort of, which I think you've emphasised a bit more in reply, about the importance of his actions, as it were, being responsible for this. The courts have sort of confronted with similar situations in the asylum cases where people take actions which mean that they become undeportable, and have said it is deeply unattractive, but you have to recognise the reality. Is there not some sort of loose analogy with that situation?
I don't think that is a correct analogy. And the distinction I draw between the two is the distinction between Article 3, the absolute right, and Article 8, the qualified right. Now, because Article 3 is an absolute right, it matters not if the person has themselves done something deliberately to put themselves at risk of torture on return. It's just simply an absolute right, and you just have to live with it and accept them. Article 8, by contrast, is a qualified right. So it's highly, highly important that the person themselves is responsible for their state of limbo. Jeunesse talks about how member states don't have to regularise status just because they're presented with a fait accompli. Yeah. And of course, Jeunesse was a family life case, and sometimes in family life cases, the considerations of other members of the family end up tipping the balance. But we're not dealing with that in this case.
Thank you.
You preserved a tiny little window.
Yes.
Do you want to use it? Or?
Tiny window. The context is everything. If we look at the paragraph 1 of Ripia, where Lord Wilson sets out what the court's being asked to think about. The primary question, this is obviously material to the ratio, the Home Secretary, at the bottom of page 5538, begins, Home Secretary determines to exercise his power to remove a foreign national from the United Kingdom. The foreign national contends that the determination is unlawful on the ground that her removal would violate her right to respect her private life under Article 8. And then it goes on. The question that the court was dealing with was what weight should be given to private life. In that context, and it's important, and I have never said that it wasn't open to the tribunal, although the tribunal shouldn't have looked at section 117. But it's important to recall that the primary focus of those sections is looking at the restrictions that Parliament places on the discretion of a judge to assess what weight should be given to private life when deciding whether or not removal is lawful. And that's the context of RIPIA. And there's nothing in RIPIA which detracts from the, we say, submission that here the tribunal was dealing with a balancing exercise of a different order.
Thank you.
There was one other matter that the court raised, which I don't know if I can assist with, and that was whether the rationale stroke incentive point was raised below. Mr. Nicola tells me it wasn't, and if one looks at the respondent's skeleton argument, which begins at core bundle 153, there's no mention of it in there. Unless I can assist further.
Thank you. Well, thank you all very much for your respective submissions. We will be reserving our judgments. They will be provided in draft in the usual way, and I now am obliged to remind you that the drafts are provided for a very limited purpose. Not for, and I'm not going to remind you what the limited purpose is, because I might get it wrong and give you the wrong impression. But it really is important that you abide by it, because you will have seen from recent decisions that the court takes a very dim view of use being made of it for other purposes. We would hope that once you receive the draft, you'll be able to agree a draft order, but if you can't, we'll deal with any outstanding issues on paper.
My Lord, I have undertaken to provide a copy of RS India, the tribunal decision. Is it sufficient that I circulate that in soft copy, or would the court like hard copies also?
I think just send it electronically.
I'm grateful.
Thank you very much.
Court rise.